Wonderful. Good afternoon, everyone. My name is Darby Hickey. I am Senior Policy Counsel at the DC Justice Lab, and I'm so thrilled to be here today with our friends Sam and Hannah from SEDEC DC, as well as all of you. Thank you so much for taking time out of your day to be here with us and learn about these important issues related to DC's pretrial detention system and how bail works in DC and threats from Congress to impose cash bail on us, which we have not had for over 30 years. We are going to go through a bit about the where things stand right now. Why are we even talking about this issue? We're going to talk about the history of our system in DC and how it works and what the congressional threats are right now. And if we have time, we'll get to some questions and answers. Oh, but before that, we'll also talk about like what's next. Where do we go from here? And so with that, I think I will go ahead and turn it over to Sam and Hannah to introduce yourselves and get us started.
Yeah, good morning, everyone. My name is Sam Pinnell. My pronouns are he, him, and I am a policy associate at ZDC. Hannah, I'll let you introduce yourself before we dive in.
Sounds good. Hi, everybody. Thanks so much for coming. I'm really glad to be here. I am a staff attorney at SEDEC DC, leading our Returning Citizens project.
Yeah, and with that being said, we will jump right in. Two things I wanted to hit at the top. One, I have a very sick elderly cat, so if you hear someone crying and meowing, that is Walden. The second is that I really hate acronyms and I do my best to avoid them. But if I use one and you are thinking, what the heck is that? Please put it in the chat and we will do our best to make sure that we get back to you on that. Yeah, so the title of our presentation, Why Cash Bail Would Fail the People of DC, that comes straight from a report that we published in November 2025. Hopefully the title is pretty self-explanatory there. But I'm going to start with just a little bit about ZEDEC DC. Our mission, as you can see, is to safeguard the legal rights and financial health of DC residents with low incomes, dealing with often devastating consequences of abusive debt collection practices and other consumer-related issues. We draw from the Jewish teachings of Zedek Tirdav, justice, justice you shall pursue, comes from Deuteronomy. I learned that passage when I first started working at Zedek, and it's something that I'm really drawn to, and I bring myself back to a lot when I'm doing this work. But we pursue our mission in three different ways. The first is legal representation. That will be Hannah's part of it. We represent people who have debt collection lawsuits or other consumer lawsuits. This is a huge need. It's vastly underfilled in DC, so we see much more demand than we can normally meet, but it is very satisfying to see our clients in that and make sure that they get represented. The second piece that I have more of a part in is our systemic reform through policy advocacy and coalition work. That looks like what we're doing today. And it looks, we will be working with the DC Council and very, very, very occasionally folks on the Hill on some federal legislation. The third is we have community outreach and education. This is often informing people about what their credit score is like, how to read, your checks that you get from work, how to do not taxes, but how to read really any type of consumer or bank product that you might get. And importantly, this includes an 8-week financial empowerment course, which is another one of my favorites. I love to sit in on that, and I learned something a lot each time. So yeah, that is a little bit about ZEDEC DC. We're headquartered at UDC, and we have an additional office in Navy Yard as well, where you can usually find me. So the big question: why are we talking about cash bail now? Our work at ZEDEC DC, like I said, focuses on a lot of consumer and debt issues. Out of that, we have a Returning Citizens project. We learned that the federal administration is looking to change DC's bail laws. Uh, the unique structure of how DC works means that the federal government has a lot of influence to be able to change DC's local laws. Um, and that makes us very vulnerable to interference with our laws and systems. So, just a few reasons we're talking about it right now is, in specific, is that there is a bill in Congress, HR 5214, which we'll talk more about. And then the Senate version you can see on the screen. They are already seeking to change DC's laws. We have executive orders coming from the president's office, which is trying to change DC's bail laws. And we also had a running number of comments about hoping to impose cash bail here in DC, including a shout out during the State of the Union by the president that he would like to impose cash bail in both DC and nationally. And beyond that, there's lots of different attacks. If you have been plugged into DC Justice Lab's other lunch and learns or just their work in general, you will see that we're being attacked from really all different angles. And that includes changes to our budget. Last year, through some changes, DC was not allowed to spend some money that it had raised for itself because of what was supposed to be a clerk or some paperwork issues and how they handled the budget. And then this year, DC tried to decouple itself from some tax changes. Happy to dig into that at another time. But once again, the federal government took that right away and will actually cost DC around $600 million over the next few years. So with that being said, Hannah, I will let you lead us more into what bail is and how we do it in DC.
Yeah, absolutely. Thanks, Sam. So yes, I wanted to start off just by talking a little bit about what is bail. I think in the popular understanding, bail is often conflated with money bail. We've all heard posting bail is paying to get somebody out of jail, but the reality is that is just one kind of bail. Bail is really simply the process of releasing an accused person until their trial date. And I think it's really important to highlight the fact that this accused person is still at this point in the legal process presumed innocent. They haven't been convicted of any crime. So it is really, a very serious question of whether to incarcerate that person. And so the two types of bail we're going to be talking about today, cash bail essentially just means that that person's release is conditioned on a monetary payment. The other kind that has been labeled cashless bail by the current administration is also called risk-based detention. And that essentially just means that release is conditioned on non-financial terms rather than financial ones. So in a cash bail system, people have to agree to pay a set amount of money. That can be from their own pockets, from the pockets of family members, or often by paying a for-profit bail bond company, which we'll talk about a little bit later, before they can be released to await their trial. There are two kinds of bonds in a cash bail system. Release may be conditioned on a secured bond. That requires an upfront payment before the person can be released. Release can also be conditioned on an unsecured bond, which does not actually require an upfront payment. It only requires payment if the person then fails to make their subsequent court appearance. So you've got secured bonds and unsecured bonds. Now, DC's system is different. The system we have in DC would be considered a risk-based detention system. This kind of system, I think, has been portrayed by advocates of cash bail as basically like an open door letting everybody out of jail. But that is actually extremely far from the truth. In reality, the Pretrial Services Agency in DC uses this really extensive risk assessment tool. It looks at a lot of different factors, such as somebody's history with the criminal legal system, like the type of crime that they've been charged with, if there have been any threats made to victims, a person's like past failures to appear in court. So really a lot of different factors are examined. And these factors are used to decide if somebody should be released, and if so, under what conditions. So if someone is released pretrial, a judge might impose any number of conditions. For example, they might impose like stay away orders that require somebody to, not go to a particular, maybe like a home or a business or something like that. There may be like mandatory behavioral health treatments, or on the more extreme end, things like home confinement. So as you can see, this system actually has a lot of restrictions and guardrails, and is very far from being an open door. The big difference here is that this system just doesn't use wealth as the metric for deciding whether or not to release someone. So it doesn't just punish poverty, unlike a cash bail system. And with that, I can pass it back to Sam for a little bit of history.
Thanks, Anna. And this is where I took notes, and I will try to stick to them because I'm a huge history nerd, so I won't try to bore anyone here too much with history. But early in U.S. history, there was a strong emphasis on individual freedom pretrial, and pretrial detention was pretty limited. A bail was set, but as Hannah kind of mentioned in her previous slide, that would be unsecured. So what that would mean is you have been accused of a crime. The judge would say, if you don't show up for this crime, you will have to pay X amount of money. And the way it normally worked is a friend, a family member, maybe even someone who's, higher up in your community or viewed with a lot of esteem will say, if they don't show, I will pay it. They did not have to pay that money at the time. They only paid if you didn't show up. That started to change in the early 1900s once cities started to grow a lot bigger through the urbanization process. Now you have more people who don't know each other, who don't have those same sort of local connections, moving more and more frequently. And so that is when you start to see cash bail, as we kind of know it today, start to grow. And that is also the same time that you see bail bond companies start around this same time. Hannah will talk more about bail bond companies later, but think turn of the century, 1900s to 1920s, you start to see cash bail as we think of it. Pretty much right from the start, people knew that was pretty bad, and that it, hurt folks who are low income much more than folks who have an ability to pay. So from 1920s on, there's already reforms to change this sort of process of how cash bail works. And in 1966, we get the Federal Bail Reform Act, where Congress encourages judges to release defendants pretrial by the least restrictive means possible. And they actually make a statutory presumption for release, meaning that judges need some sort of reason to hold you pretrial. And we normally want to let people go back to their communities. We continue this sort of slow trickle of reform, and in 1984, we give judges the power to consider public safety when they're determining pretrial detention and bail amounts. These revisions are mostly aimed at giving judges a lot of discretion on how they impose pretrial conditions, whether that's cash bail or whether that's physically holding someone in jail until their trial. We wanted judges to be making that decision. And DC locally follows pretty much the same track. In 1970, we allow a provision, or DC adds a provision to allow the court to consider the safety of the community in setting non-financial conditions of release. Over the next 20 years, additional reforms required judges to consider other factors in assessing pretrial release, and they introduced a lot of new options for non-financial release. This could be a lot of the things Hannah was talking about, attending classes, curfews, wearing an ankle monitor, all of those things start to come in then. In the 1990s, there's several high-profile crimes from people who are out on cash bail. I won't dig into those, but the Washington Post has a lot of history about the discussion around cash bail in the 1990s. There were a lot of op-eds. There's a lot of ink spilled about ending cash bail in DC in the 90s as a response to this. And so the DC Council holds a lot of hearings. And what they ultimately come up with is the Bail Reform Amendment Act of 1992. And we've had that for more than 30 years. The law removed money from the decision to release or detain someone pretrial. And it makes sure that folks are not held in detention simply because they're not able to pay. So it really, really emphasizes the public safety aspect. It eliminates cash bail in 1992, which made DC a national leader. We have the earliest elimination of cash bail in the country. And an important note, bail bond companies also pretty much end overnight in 1992 as far as operating in DC. Yeah, Hannah, could you go to the next slide? So I want to preface this by saying that DC's bail laws have been incredibly successful. That does not mean that DC policing has been incredibly successful. It just means that our system of making sure that people show up to trial has been very, very effective. And this slide shows, how effective that's been. So in the most recent data, we have 98.8% of community members released home pending trial over a 9-month period, successfully returned home, without any violent incident. So 99% of people who get released do not have a violent incident. The vast majority of these people do not get rearrested for any crime, 90%. And right around that same 90% number attend all scheduled court appearances. So 9 out of 10 people are appearing in court every time they need to. They're not getting rearrested. And almost everyone, 99%, are not having any sort of violent incident as they await trial. Could you go to the next one, Hannah? So I wanted to give that history. I know it's lengthy and long, but to show you that we have thought a lot about bail in DC, and we very intentionally came up with the system that we have now, which is part of what makes the federal government targeting bail system to be kind of strange. It's, you will hear advocates for cash bail often talk about how we need cash bail for safety, public safety. We had a long series of chats and hearings, and like I said, tons of ink spilt on why this is a bad idea. And we ultimately came up with a system that, like Hannah said, prioritizes safety over your ability to pay. So in August 2025, New York House Representative Elise Stefanik introduces HR 5214, or the District of Columbia Cash Bail Reform Act. It passed the House in November. It's currently awaiting a vote. I'm kind of sad to say that we had hoped that more Democrats would vote against the bill, but we had about 30 Democrats vote for it. So it wasn't quite the strict partisan vote that you might see on other bills. Yeah, Hannah, can you go to the next one? Yeah, and so what the bill does is it does two things. It says we need to hold more people in pretrial detention, and for folks with other types of crimes that they're accused of, we need to make them pay cash bail. So sorry, give me just a second. This is why I gotta stick to the notes. So there's already a category of crimes that are called violent or dangerous crimes in DC's code. Those crimes are already, we have a presumption that if you're accused of those, you're going to be held pretrial. What this bill would do is basically remove the small amount of judicial discretion that exists for those. So currently, if you're arrested for things like burglary, robbery, child cruelty, murder, carjacking, sexual assault, and many other crimes, you are presumed that you need to be held pretrial. But if a judge thinks that it's safe to release you, and the judge makes that determination, you can be released. It's very difficult to break that presumption, but it's possible. This bill would take away even that small amount of judicial discretion. If you're accused of any of these crimes, then you will be held pretrial detention until your trial. The second thing the bill does is create a new category of crimes called public safety or order crimes. Hannah, could you go to the next one? This category includes all the things you see on the screen, but things like destruction of property, inciting a riot, fleeing from law enforcement officers. These categories would require a defendant to pay cash bail to be released, would also make it where you can see in the last bullet there, if once you're convicted of one of these crimes, you have to pay cash bail for anything that you're rearrested for, even if it's not connected to one of these crimes. The real scary part of these crimes is that they're often connected to protesters. If someone is arrested at a protest, they will often be charged with one of these types of crimes. That is scary because this administration or any other could use this to jail protesters in DC and then make them pay cash bail before release. So you could imagine someone misusing this ability, this administration or any other, to crack down on people who are saying things that they don't like. And I think that is the real harm and danger of this bill, other than all the things that Hannah will be talking about in the next few slides on the effects of cash bail. This part of it is pretty clear. I think that they would like to use these laws to get at some folks who are disagreeing with this administration's decision. And I will pass it to Hannah for the next part of that.
Sounds good. Thanks, Sam. So yeah, I want to talk a little bit about the effects of cash bail. First of all, there is just really extensive research that shows that cash bail does not actually make our communities any safer. There was a comprehensive study done in 2024 by the Brennan Center. It actually looked at 22 cities that implemented some type of bail reform. And that study found no statistically significant difference in crime rates between cities that had reformed their bail policies and those that didn't. So the question is, if cash bail doesn't make us safer, what does it do? And I think, you can say that meanwhile, other studies have shown that actually assigning somebody money bail actually puts them at higher risk of future arrest and incarceration. And we'll talk about all of the reasons that you can imagine that that might be the case. But some of the effects that we might expect to see in DC specifically, because cash bail keeps people in jail solely because they can't pay, it probably comes as no surprise that it disproportionately is going to impact people with low incomes, people who don't have just a lot of wealth. It would also be, really set to exacerbate just already stark racial disparities in the district, where we have a criminal system that already disproportionately stops Black residents and detains them pre-trial. Under cash bail, we would expect to see more of that. Cash bail also drains community resources, and it does that in a number of ways. One, it just drives up taxpayer costs by virtue of leading to higher rates of incarceration. It can force families to make just really impossible financial decisions about, whether to go into debt or maybe to use this kind of predatory bail bond company in order to get their loved one out of jail. And there are also, something that doesn't necessarily get covered as much, but a lot of indirect costs that are also costs to the community, like evictions, lost wages, adverse health outcomes that people might experience as a result of pretrial detention. All of these things are drains on the community and drains on public resources. So cash bail, we assume, is likely to lead to higher rates of pretrial detention, especially, again, for people who don't have a lot of resources. And the data on pretrial detention shows that it is actually extremely harmful. People miss work, they have loss of income. This missed work can lead to job loss. Lost income and job loss can lead to loss of housing, especially if just nobody is there to pay the bills. Parents who are detained pretrial have lost custody of their kids. Just generally, it produces an enormous strain on families and causes a lot of family instability when a family member is in pretrial detention. And just generally speaking, studies have shown that even really one day in jail can produce a lot of these negative outcomes. And that just increases with the more number of days or the more days somebody spends in jail, the more likely they are to have these negative outcomes. And even though these negative outcomes can happen really fast, they can again happen within one day of somebody being detained pre-trial, they don't go away quickly. They last for years into the future, and these negative outcomes have been shown to persist for people for years into the future. So, like I said, there's a lot of data on the negative effects of pretrial detention, but I did also just want to share a story. Like I said at the top, I'm a staff attorney at Zedek DC, so I have clients, and one of my clients was generous enough to share her story of pretrial detention for the report that we did on cash bail. And I think her story really stands out because she dealt with almost every conceivable negative consequence of pretrial detention that you could imagine. She was, first of all, just in a really basic level, she was unable to, for months, access medications that she needed. She had to negotiate back and forth to get even these basic medications. So her mental and physical health really deteriorated while she was detained. She and her family were evicted from their home. There was nobody there to pay the bills, and they ended up being evicted. Her car was repossessed. Again, nobody was paying the bills on the car. Her car was repossessed. Her dogs were taken to the shelter. And I think the worst thing for her was that she didn't know where her kids were. She knew that she had been told that they were staying with a family friend, but she couldn't get any information on who that family friend was or really what was going on with them, which was just absolutely horrifying. And so, like I said, she dealt with basically every conceivable consequence and described it as basically seeing her entire life go down the drain within a matter of weeks. She had been charged with something nonviolent, so she was expecting to be able to go home to await her trial. But when she wasn't, all of this happened. And because Zedek DC, we're a consumer organization, she had actually come to us as a victim of identity theft. And that was identity theft that had happened while she was incarcerated. And, obviously, I can't say for sure that that would not have happened if she had been able to go home pre-trial. But it is definitely true that because she wasn't able to go home, she wasn't able to do things like put her affairs in order, to secure personal documents or, her wallet, debit cards, things like that. And as a result, she, lost thousands of dollars essentially to this instance of identity theft. And it hit her, extremely hard. It made it much more difficult for her reentry process when she did come home. And, for a lot of folks, some of these effects, just like life effects and then also these consumer effects, can be kind of mitigated if somebody has a chance to go home and again kind of put their affairs in order. Even so that way, even if they are sentenced, if they are convicted and do spend time in prison, they've had that opportunity to go home pre-trial. Just wanted to share that story. But then I also wanted to talk, I know we've been talking kind of before about these bail bond companies, and I wanted to share, a little bit more about these bail bond companies. So essentially, a cash bail system would kind of set up a big flashing sign inviting bail bond companies to set up shop in the district again. Um, and these companies, I'm sure people have, seen them, heard of them. They're very common in the United States. But they're actually really unusual by other standards. The US is one of actually only two countries that have these for-profit bail bond companies. So they're really not a common practice worldwide. And their business model, honestly, is just to profit off of desperate people. Typically, what they do is they charge 10 to 15% of the bail amount as a non-refundable fee. So typically, if somebody is just able to post bail, then the idea is that they're supposed to get that money back when they appear for their next court date. But if they use a bail bond company, then a portion of that is going to be they're going to pay and they're going to lose because it's non-refundable. So in exchange, the bail bond company then enters into an agreement with the court to pay the full bail if the person fails to appear at a subsequent hearing. But one thing that I learned in this research, I think contrary to popular belief, bail bond companies actually usually don't pay the full bail amount to the court up front. They're able to provide surety bonds. So essentially they promise to pay, but they're often able to kind of slip out of their obligation to pay or escape liability, even if a person doesn't show up to court. So often that cost is something they manage to evade, and that is profits that they can pass on to the big insurance corporations who are largely dominating this industry. So it's estimated that bail bond companies collect $1.4 billion in non-refundable fees annually. And again, these are fees collected from people who are already extremely vulnerable and likely don't have a lot of assets, and that's why they're using these bail bond companies in the first place. And these companies, fortunately, have been absent from the district for decades, for a really long time. But one of our big concerns with cash bail is that that would be just inviting them to return. Another thing we wanted to talk a little bit about is the effect that we might expect cash bail to have on the state of the DC jail. So as a lot of folks on this call probably already know, the DC jail is already dangerously overcrowded. It's really unsafe. The death rate has been estimated at 3.5 times the national average. And with the recent surge in federal law enforcement, we've already seen increases in the jail population. The Council for Court Excellence had data last year showing that there was a 10% increase in the jail population between August and October 2025, around when that surge in federal law enforcement happened. So we've already seen an increase, and cash bail obviously would lead to more pretrial detention, which could also then lead to a higher jail population and even more overcrowding. And any jail stay is going to be traumatic and often dehumanizing. These facilities are often overcrowded. Most people who are in jail are likely to witness violence, or even become victims of violence themselves. And cash bail threatens, again, to increase the jail population and to really produce these effects for even more DC residents who might be detained pretrial. And incarcerating somebody at DC jail is also really expensive. It can cost $241 a day to incarcerate one person. It's estimated at over $500,000 every day to incarcerate the population of DC jail, and over 191 million every year. And introducing cash bail, the risk is that these estimates are going to run even higher. And this is money that DC could be using for a lot of other better things, like funding schools, infrastructure, mental health providers, just its facilities. So the costs that would likely be increasing in incarcerating people at the jail under a cash bail system could be used for a lot of better things. And I will go ahead, I think, and pass it back to Sam.
Yeah, thanks, Hannah. I was on the call with Hannah when we discovered that bail bond companies often get out of paying bail when someone does not appear. And I think it took a few weeks for both of our jaws to come up off the ground when we learned that. But we also wanted to highlight, we think HR 5214, the bill that I talked about earlier, is probably the best bet to change DC's bail laws, but there are a few other threats that are lingering out there. The first, which came out at approximately the same time as HR 5214, was an executive order by the president titled Measures to End Cashless Bail and Enforce the Law in the District of Columbia. The executive order instructs the U.S. Attorney General to impose harsher pretrial detention policies in D.C. and take appropriate actions to end risk-based detention. The order is really vague And it mostly says if the Attorney General doesn't like DC's bail laws, then they have the backing of the president to press the District of Columbia to change its policies with respect to cashless bail. Like a lot of other executive orders, this is very squishy and gives the Attorney General a lot of latitude. But we haven't seen any changes on that front yet coming out of that executive order. Another executive order titled Taking Steps to End Cashless Bail to Protect Americans was signed around the same time. This authorizes the Attorney General to see which jurisdictions do not use cash bail and identify what federal funds that could be withheld from those jurisdictions until they change their policies. That bleeds right into the next bill that I have up there, HR 5213, also brought forward by Representative Stefanik. This bill would withhold federal JAG burn program grant funding. This is funding that's, I think, been around since the 80s or 90s and goes to local police departments around the country. The amount of funding is pretty small when you look at it in the context of DC's MPD budget. But where this could really hurt is if there's some smaller towns or cities that do not use cash bail, and those grants are a much bigger part of their funding. But it would think in terms of DC, we got 1.3 million in JAG burn funding out of maybe a $90 million MPD budget, if not higher. And the last thing that I wanted to note as far as kind of other concerns, we have been in a lot of meetings with other coalitional allies or Hill staffers, and they have mentioned a looming criminal omnibus bill. We do not have any details about what this will look like. It sort of hangs in the background of all these conversations we've had where they're like, well, we don't think this bill will move, but criminal omnibus bill is coming, and it always has these very serious undertones attached to it. We think part of anything that comes out of an omnibus bill will probably include provisions on cash bail, but we don't know exactly what those will be. The current dysfunction in Congress, if anyone has tried to fly lately, you were probably very aware of that. We think that's a reason this has been delayed amidst many other things that are probably vying for attention by Congress. But we are keeping an eye out for this, and we do expect it to come probably sometime this year. Hannah, could you go to the next slide? Yeah. So Darby's been sharing all of the links that we've talked about in the chat, but we just wanted to make sure afterwards people still had access to them. I really wanted to highlight the first one. We, along with DC Justice Lab and CCE, put together a coalition letter that we sent out before the House vote on HR 5214 back in November. We are still keeping that coalition letter alive. We plan to send it to Senate leaders when it pops up. We're currently at around 200 signees. Our goal would be 300. So if you haven't signed on to that, I would heavily encourage you to take a look. And if you have any questions, feel free to reach out to me about it. And the last thing that I will mention is that we do have a memo on how these cash bail bills could violate the Constitution. We don't have it linked somewhere on our website, so that's why I have the available upon request. If you're interested in that, feel free to just reach out to me. Yeah, Hannah, could you go to the next one? Yeah, and so, what's next? We've kind of told you about the history of it, but, what are we looking at in the future? I've talked about it several times. HR 5214 passed the House. It's now just sitting in the Senate. It's awaiting a vote. We don't know if or when that vote will happen, but one thing that we're pretty sure of is if a vote does happen, we will have very little advance notice. That's a part of why we're sharing the coalition letter now. We're trying to educate people now. We think that we might have just a few days heads up that a vote is coming when it is scheduled. So for that reason, if there's something from today's presentation that really stuck out with you about the threat to DC's bail laws, share them with family, friends, colleagues. One thing that I've been advocating for people is if you have friends, family in Maryland and Virginia, these people will be affected by this too. Share it with them, and have them contact their congressional reps. If you're in DC, we've been advised by some uh, staffers in our Senate meetings that we should start reaching out to Maryland and Virginia senators now. So if you are interested in that, please feel free to reach out, or you have all the information that we have. So please reach out and contact them if you have the time, and this is something that you feel passionate about. But otherwise, with the looming bill that I was talking about earlier, keep a lookout for calls to action on either that vote or other things that will pop up in this. And I know DC Justice Lab and our social media and email blast will keep you up to date as well.